would like to introduce Jackie Connell. Jackie is an attorney, but she is also Achieva Family Trust's vice president. So she's going to speak to you about saving for the future with special needs trusts and ABLE accounts. Jackie.
I'm Jackie Connell. I'm the vice president of Achieva Family Trust. Thank you all for coming here today. I might have seen you guys before, met some of you before. Happy to entertain questions as we go along. I'm already bored listening to myself, so I'd love to listen if you have questions or comments to make, so feel free to just throw your hand up and interrupt. I will try to repeat the question for the people that are listening remotely. We're going to go through some of the different legal options to consider as you're planning for the future for a loved one with a disability, or if you yourself has a disability, some of the things that you would want to consider and the different legal options that are available. So to start with, government benefits, we'll talk very briefly about some of the government benefits that we need to be aware of protecting when we're doing a future plan. We could do probably an hour on those benefits alone, so I'm just going to cover them at a very high level. We'll talk about legal options available. So last will and testament, I'm sure, is a concept we're all familiar with. Special needs trust, maybe we're a little less familiar with those, so we'll talk about the different types. We won't talk about guardianship or powers of attorney at all, so not sure why that's even on there, but it is. But I will entertain questions about them. We just won't get to that today. Again, that's probably an entire session, and perhaps we can look to do that in the future. And then we'll hit on some other future planning tools that are available. Letter of intent is something that you can put along with your future planning documents, where you really provide future caregivers or family members information that you'd want them to know about your loved one with a disability, likes, dislikes, just really intentions for the money that you're planning to leave to the individual with a disability. So it's more of an informal document. We're not going to memorialize every thought that we're having in our will or in our special needs trust. So a letter of intent or a future planning guide, really nice options, again, to just track some of the information that you'd want to pass on to future caregivers or family members that might be involved in the life of the individual with a disability. And then hopefully we'll get to ABLE accounts. I always promise that and then run out of time. So we will talk about that a bit as well. Okay, so setting the stage a bit with government benefits, there are two types of government benefits to be aware of, needs-based versus entitlement. So we'll focus mostly on needs-based benefits today. That would include supplemental security income, or SSI, which is a cash benefit available to people with disabilities. Medicaid or medical assistance is a health insurance benefit available to individuals with disabilities. And then Medicaid Waiver Services, or long-term care. It's another Medicaid program. The term waiver exists. In the 80s, there was legislation that effectively waived the institutional requirement for, nursing level or facility level care. And it allows individuals to live in the community and get the care that they would otherwise receive in a facility. But again, allowing them to be integrated in the community. And all three of those types of benefits have very low income and resource limits. So an individual receiving those benefits is not allowed to have a lot of money in the bank or receive a lot of income per month. So we'll talk about that. And then entitlement benefits we won't get into too much today. Those would include Social Security disability income. So if an individual has worked and has paid into Social Security during their working life and they become disabled, they have the ability to collect Social Security disability off of their own record. Social Security survivors benefits is when the individual with a disability collects Social Security off the record of another. So it could be a parent that later passes away or retires or becomes disabled. Could also potentially be a spouse. So again, we're collecting off of someone's work record that paid into the program. So the question is, does someone have to die in order to get the survivor benefit? So there's a couple different, survivor benefit sort of refers to when you have a kid that's under 18 that collects off of a parent that passed away, but it also could be triggered by an adult who has a parent that passes away. They can collect off of a parent's record at death, but oftentimes it will occur before death and at a parent's retirement, or if the parent themselves become disabled, the disabled child also has the ability to collect off of that parent's record. Are you okay with me repeating the question?
Yeah.
Okay.
If you want me to,
Okay.
I could do that.
Okay, sorry. And then there's Medicare. I'm sure we're familiar with that as a concept. An individual becomes eligible for Medicare by age at age 65 upon retirement, but also becomes eligible for Medicare after collecting Social Security disability for at least 2 years. So if you have an individual that becomes eligible for Social Security disability, a survivor benefit, they will become eligible for Medicare after 2 years. Medicare will actually become primary and their primary source of health insurance. But I mention these entitlements because it's critical to understand that even if you are receiving these entitlement benefits, there's a very good chance that you're also eligible for one of the needs-based benefits, whether it's a dual eligibility with SSI and SSD, or more importantly, a dual eligibility with Medicare and Medicaid. So even when an individual becomes eligible for Medicare, there's a lot of gaps in coverage in Medicare. It's not really an all-inclusive insurance. So often the individual can still qualify for Medicaid to pay for prescriptions, to pay for a Medigap or Part C part of the plan. So even if you have an individual that's on SSD and Medicare and think, okay, I don't really need to do future planning, these are entitlement benefits, they don't have resource and income limits, be aware of the fact that the individual could be eligible right now and already receiving Medicaid benefits, or could become eligible for Medicaid benefits in the future. So there's a lot of instances where people are dual eligible for these types of benefits. So you still have to plan for that as part of leaving money to that individual, because we don't want to jeopardize any needs-based benefit that they may be receiving.
Does that start at a specific time? Like, when can a person apply or make that happen? Is that
Which-
like for Medicare or Medicaid?
So an individual can become eligible for SSD or a survivor benefit. Again, someone had to work at some point to pay into the program. So if there isn't a work record that we can collect off of, it's usually going to default to SSI, because all SSI requires is that you're low income and have a disability. So a lot of times people might start out on SSI, and then when a parent retires or passes away or becomes disabled, they then become eligible to potentially collect off of that parent's record.
Okay. But as far as the health insurance, the health piece, does that coincide with eligibility?
So for Medicare, yes, you have to be on SSD or one of these survivor benefits for 2 years before you're eligible for Medicare. Medicaid would need to be in place or continue during that 2 years.
And if you have a parent with a disability and you have a child with a disability, are those linked as well?
So the child is not going to be able to collect off of the grandparent's record. So, but there is potential, and this is kind of getting into the weeds a little bit, that a grandparent can sort of shift their own assets to a disabled grandchild as a way of becoming eligible themselves for certain needs-based benefits, but they're unable to collect off of their record the way I just described with parents.
Thank you.
And like I said, we could do hours, maybe 2 hours. I don't know where Matt Bailey is. We can come in here and do this for an hour after, but yes, sure.
So, Medicaid, younger children can have that as their secondary insurance, correct? Right
Yes,
now?
absolutely.
Okay.
So-
Like, that's like the loophole insurance type of thing for wraparound?
Absolutely.
Yes?
Children
Okay.
can be on Medicaid. They also can be on SSI. I mean, the difference with SSI eligibility for a child and exactly, they're looking at household income for a child in SSI. So the entire household's income is considered. When the child turns 18, only their income and resources are considered. So for a lot of people that have children living with them, it's tough to qualify for SSI for a child if the parents are working or what have you. So the question is she has a child that's 15, will she become eligible for SSI at 18? So it's not automatic. She has to go through an application process. She'll have to apply both from a financial standpoint as well as a disability standpoint. So Social Security will need to deem her disabled, and they will review her financials like they would for anyone else. They'll look at income, they'll look at resources. They will not consider your income or resources in doing that evaluation. Just hers. No, I think it actually very much helps them, because if you can get, the tricky part about all of the Social Security benefits is getting the disability determination. But they're going to be evaluated again as an adult. It's kind of a new application process. So we're kind of starting all over again. So if it's a clear disability and we already have things in the record, like an IEP in place, medical records, it's likely to be an easier process. But I can say just from experience, it's been nightmarish lately. I mean, the most obvious of situations are taking forever to get determined. People get denied on the first try just because that's what Social Security does and puts you through the appeal process. So you will have to go through the process, and it won't happen overnight. But I absolutely recommend doing it, no doubt.
Along those lines, can I just mention it's very important for your IEP to clearly give the correct primary and secondary diagnosis, regardless of all the medical records and everything else you have.
And I practiced in this field in Social Security, and I saw many, many, many children who had SSI as a child had the disability as a child who were denied at 18 because they also base it on what's your functional level. As a child, they're not getting to that, are you employable kind of question.
No, appreciate the clarification. Yeah, no, I mean, benefits are, and this is why I never get to ABLE, by the way, because there usually is a lot of discussion around benefits. But yeah, I mean, it is a very in-depth topic, and perhaps for the planning committee, Patty will do something entirely on benefits at the next conference, because it's very much into the weeds. It's very difficult to navigate. I mean, talk to your supports coordinator or service coordinator. They should really be the person that's leading the way on these types of applications to help you navigate.
And call the Achieva Family Trust Benefits Counseling Team.
Matt Bailey.
Matt Bailey.
Yeah, call Matt Bailey at Achieva. He can assist as well. I'm going to keep saying his name. Okay, so we might have said some of this already, but to get a little bit more detailed into SSI and Medicaid. So again, in order to qualify for SSI, it is a needs-based benefit. There needs to be a chronic disability in place as well as low income. So both of those things, again, will be evaluated upon application. In 2023, the maximum cash benefit at the federal level that a person can receive on SSI is $914 a month. So Pennsylvania will kick in $22.10, woohoo, as an additional cash benefit. But I think we can agree, all of us here, that it's pretty difficult to live off of $950 a month in the world that we're living in. I mean, that you've got to pay your rent, your utilities, even if you're on subsidized housing, even if you have SNAP benefits, you're going to need additional funds to live. And so that's really what we're talking about here when we're talking about planning. It's how do family members who have money that they can potentially leave to allow the individual to live a more robust life, do that without impacting these critical benefits. So that, again, this is kind of why we're here today. And with SSI, there is a $2,000 resource limit. So again, even a small settlement, a small back payment, small sum of money can put the SSI eligibility into jeopardy. And for a lot of people, the SSI cash benefit may not end up being of the utmost importance, particularly if you have a family that's wealthy that intends to leave a lot of money into a trust for the individual. But it's the Medicaid that's linked to SSI that can be critical. So if you receive even $1 of SSI in Pennsylvania, you're automatically eligible for Medicaid. So again, even if you don't get the full SSI benefit, or even if the cash flow a month isn't of concern, that link to Medicaid often is. So it becomes important to maintain that eligibility for SSI. Medicaid, again, also a needs-based benefit. The general health insurance that's connected to SSI carries that $2,000 resource limit. So again, that's all bank accounts, all retirement accounts, everything together can't have more than $2,000 to be eligible for these benefits. Waiver services and long-term care, the asset limit's a bit higher. If the waiver program allows you to have $8,000 in assets, and waiver's sort of the big one. It's paying for a lot of different community programs. So if an individual's in a group home, it's paying for the cost of living there, different types of attendant care and in-home supports, respite, day programs, and different therapies that if you were trying to privately pay for these things, you'd be talking about, tens of thousands to hundreds of thousands of dollars a year. So this Medicaid is really, really important to maintain for folks with disabilities. And as you can see, again, you're not allowed to have a lot of money in order to become eligible.
Is that based off of the individual? So if they're applying at 18, it's their assets, not the family's?
Correct.
Okay.
Yeah, so when we're talking about becoming eligible for any of these means-tested benefits as an adult, we're only looking at the individual with a disability. We're not looking at parents. And when we're under 18, that's when the factors change a lot. And not only that, with waiver, when a child has parents that are there to take care of them, oftentimes they're placed on waiting lists, and the availability of funding is a lot less than when someone becomes an adult and there's an expectation that they will live alone or be able to take care of themselves. So the eligibility piece changes so dramatically from being a minor to 18. And so, to the gentleman's point in the back, it really is important that the IEP is, correct, that we are, very serious about goals. We know the types of support that's needed, so that we're making a case to Medicaid, to Social Security about what is needed for the person to live, independently, that it's all there. We don't want to have to start trying to prove that case after the fact. So it's really important to have the IEP and ISPs up to date.
With this $2,000 limit, $8,000 limit, does that include like trusts that are set aside from, say, grandparents?
So we're going to get to that today. It doesn't include special needs trusts that are set up by grandparents or others, but regular trusts or support trusts that don't have special needs language are resources. So that's why it's so important to do this planning around this, because if we don't draft the trust properly, we're going to miss the benefits of it.
So as long as it's special needs, it is not included with this.
As long as the trust is a special needs trust, it will not be counted as a resource in terms of these benefits. Leanne, we have a question back here.
Sorry about that.
Is the asset limit of $2,000 or whatever at the time of application, or like month by month? How does that work?
It'll be at the time of application. So you'll want to prepare that when the application's made, that the resources are under the limit that they need to be. And we'll talk about some more of that. Correct. Correct. Okay. Now that we got past the benefits portion of the programming, Matt Bailey, you'll be here next year doing this.
Keynote speaker.
I'm like getting nervous because I'm like not a benefits guru. I know the basics, but the weeds sometimes get me a little nervous. But okay, future planning, more of my lane. So I usually talk about what we want to avoid. So direct inheritance is certainly something we want to avoid doing. So this would be leaving assets directly to the person with a disability, whether that's in a will, whether that's someone dying without a will and the person inheriting through the state's laws of intestacy. That receipt of inheritance could have immediate impact on the person's benefits. They could lose them, they could have them reduced, and they could even have to overpay them depending how long they are over-resourced and still receiving benefits. There are types of trust that you can utilize, and I'll hit on them today, that if someone does receive a direct inheritance, there are special needs trusts available. There are limits on those types of trusts, age limits, limits as to how money remaining in trust has to go. So it is not what we want to do as part of a future plan. If we get into a situation where someone comes into money, we're glad that we have trust available to shelter those resources. But when we're talking about planning for a loved one with a disability, we do not want to leave that to chance. So direct inheritance is definitely not something we want to do as part of the future plan. Similarly, disinheritance, we don't want to do. I just had a case probably within the last week or so where parents left the bulk of their estate to the non-disabled child to use for the benefit of the disabled child. And a bunch of people are standing around scratching their heads trying to figure out where that money went. So, I mean, that, of course, is an insidious situation where you have a sibling that just flat out steals the money from the individual with a disability. So I'm not implying that we have those people in our family. Some of us might. But beyond that, even if it's not something as malicious as that, if you have the non-disabled child get into a divorce, have to file bankruptcy, have some kind of settlement against them, that money is then placed into jeopardy. So we don't want to count on, no matter how trustworthy the person is, we don't want to count on someone else to hold the money to take care of the individual with a disability. It's not necessary. We have trusts available that basically have the same goals and purpose, but a lot less risk and chance, so that we don't want to do that. And then we don't want to count on asset transfers. So transfers for less than fair market value, so think gifts, just giving money away, are penalized by Social Security and medical assistance that can lead to a disruption of benefits. So someone can't inherit $20,000 today and give it to their brother tomorrow and say, oops, I'm under the resource limit again. Medical assistance on annual reviews looks at all bank statements to see money going in, money going out of an individual's account. And similarly, when you apply for these benefits, depending on what the benefit is, these agencies look back 36 to 60 months to see all transfers that the individual made from their bank accounts. So if there are miscellaneous transfers that we can't account for, we don't have receipts for, that we're not sure what they're for, there will be a penalty period before the person will become eligible for benefits. So we can't gift money away as a means of divesting ourselves of assets. So we obviously know, after the lengthy discussion on government benefits, that the whole goal here is that we don't want to lose government benefits for the individual with a disability, and we need to always be mindful of those very low income and resource limits that apply. So we do have options, fortunately. The one I'm going to focus and emphasize the most today would be a third-party trust. It's the appropriate tool when we're talking about planning for a loved one with a disability. We will touch on first-party trust briefly, again, in a situation where either the plan was missed, we didn't get a plan in time, or the individual came into money themselves that has nothing to do with an estate plan. And then we'll talk about ABLE accounts, what the requirements are for those, and how they can work in conjunction with a special needs trust. Okay, so why special needs trust? At this point, protect government benefits, we know. That is our main reason of having a special needs trust. We want to protect eligibility for government benefits for someone with a disability. However, there's the ancillary benefit of the oversight in the management. We have a lot of beneficiaries at Achieva Family Trust who may be strictly on entitlement benefits or may not yet be on benefits, but there is a concern about their ability to manage money and being taken advantage of and things of that nature. So nonprofits and different corporate trustees are available to administer these types of trusts. Again, is more of a protection, not only to protect sometimes the beneficiary from themselves, but also from other people that might be trying to take advantage of them. The nice thing about a nonprofit corporate trustee like Achieva Family Trust is that we generally will take trusts that are small in size. So our minimum to open a trust is $500. Most banks, corporate trustees, you're looking at probably $250,000 to $500,000 to even access their services. So nonprofit trust companies are available to, again, for people who may not have that significant of wealth. But again, you don't have to have significant wealth to still disrupt benefits for someone in your life. The $2,000 is not a lot. So even if you leave $10,000 to someone, that's problematic. The trustee has sole discretion around distributions, and we generally don't need court intervention or anything like that. The trustee is using sort of their skill set and knowledge around benefits to make disbursements on behalf of the individual with a disability. And generally speaking, we don't make cash disbursements from a special needs trust. So, again, this gets back to protecting the individual with a disability from others. If we're making cash disbursements, we can't really keep track of how it's being spent or who's using it. And if we're making cash disbursements, we're creating an income stream back to the beneficiary, which is obviously what we're trying to avoid by setting up this trust. Similarly, special needs trusts are what we call spendthrift trusts, which means they cannot be attached by creditors. So the beneficiary can't go out to a car dealership and say, hey, use my trust as collateral to buy this, new Bentley. That's not possible. The trust is spendthrift. It's not able to be encumbered by the beneficiary. And similarly, creditors cannot go after the trust.
Terminology for trustee
Sure.
is Achieva Family Trust the trustee?
So we'll get to that.
Okay.
Yeah, we'll get to trustee discussions shortly. But
Okay,
yes,
and
we
what-
are one option.
You're one option, but you could also
Correct.
have the siblings of the special
Yes.
needs child be a trustee.
That's right.
One more question. You said you don't make cash distributions from a special needs trust. I foresee in the future that my daughters could be the trustees and taking care of my son with special needs. But I could also see they incur lots of expenses associated with taking care of their brother. How do they get reimbursed for their cash expenses?
to him.
You can't give, but you can.
Correct. We of course can make disbursements, but it needs to be to third parties. So we can either,
So we could go to siblings.
correct.
looking out over the person with special needs.
Correct. So the trust can reimburse family members, siblings, what have you, that are making purchases on behalf of the individual with a disability. So and that happens all the time. People are out shopping and they go, oh, we wanted to buy this iPad. We didn't really want to get into the weeds of having to call and figure it out. We just bought it. We're going to submit the receipt. Can you guys reimburse us? That's completely fine. We just can't give cash or write checks directly to the individual with a disability. Again, it's creating an income stream and also putting those assets in jeopardy in terms of what's going to happen to them once they're in their hands. Okay. So getting into some of this. So generally speaking, special needs trusts are used for the supplemental needs and extra care over and above what the government provides. So we don't want to make disbursements from a special needs trust for something that a government benefit should be providing. So whether that's some kind of special therapies, caregiving, medical procedures and things of that nature, we obviously want to tap into the benefits the person is receiving before we start tapping into the trust. However, there are things that, Medicaid won't pay for. They may only pay for a wheelchair that's sort of basic every so many years, and the beneficiary might have a need for a power chair, given their circumstances. So we can certainly do something like that from the trust where Medicaid wouldn't otherwise pay for it, but we do want to, again, tap into the benefits before we tap into the trust. All disbursements from the special needs trust should be for the sole benefit of the beneficiary. So that's a Medicaid rule. Again, they don't want to see us buying things for other people or transferring money to other people. It needs to really be for the primary benefit of the beneficiary. Of course, things will benefit others, in some way. We buy a TV for the beneficiary and someone else watches the TV. I mean, we can't obviously control it on that level, but if the beneficiary is asking for a TV every month, we're really going to wonder what's going on there. Are we selling TVs or TVs being stolen? Like what's happening? So that's really the trustee's obligation to keep an eye on things like that, because that would be unusual. But again, buying a TV for a beneficiary and other family members benefit from it, that's okay. Buying 7 TVs at once, we really have to question what's going on there. So some of the supplemental needs that we can buy, again, clothing, we do a lot of vacations, again, medical needs that aren't being paid for by Medicaid, transportation, whether that's buying a vehicle or paying for Uber, we're doing a lot of that these days. Recreation, so going to sporting events, going out in the community, museums, concerts, things of that nature, entertainment. So really, again, all of these things that when you think about, if you have someone on SSI getting $914 a month and having to use that to pay for all of their basic needs, how really can they afford to go to concerts and Steeler games and go on a vacation every once in a while? And that's really where the money in the trust comes into play. It affords the individual the opportunity to have money in this trust that is available for these types of life-enhancing things. Again, we really don't want to be using it for the basic needs.
What if the basic needs exceed that 914? What if the basic needs exceed that?
You're a bullet point ahead of me every time.
Okay. I'll wait.
So now take a breath.
So good, great question though. So the whole supplement versus supplant. Again, we want to supplement, not supplant government benefits. But we do run into circumstances a lot where, as was just described, either the SSI or Medicaid isn't covering what needs to be covered, or we see an opportunity to put the beneficiary in a better situation by using the trust. So just for example, what comes up for us a lot is you might have someone on SSI who has a very large trust who really could afford to be in a nice rental property, paying market rate that they could never afford on the SSI. So the trustee does have discretion generally in these trusts to make a decision like that, to say, okay, we can put the beneficiary in a $1,500 a month apartment. It has all of the accessibility requirements that are needed and just a better life in general. We can make that decision as trustee to use the trust for something like rent, which is what SSI is supposed to cover. But we do have to be aware that if the trust is paying for these types of things, rent, utilities, or food, and the person's on SSI, the SSI is going to be reduced, usually by up to a third. So instead of getting the full $914, the beneficiary might only get, say, $600 per month. So it is a judgment call that has to be made by the family and by the trustee. But we do run into a lot of situations where that does make sense. It just makes sense to help the beneficiary instead of them struggling every single month because we have money available. There are a lot of situations where it doesn't work like that. We have $20,000 in a trust for someone and they're on SSI. If we're paying $1,500 of rent every month, that trust is going to be gone in a year. So it really is a balance, and sort of we'll talk about the trustee piece. It's why when you're deciding on who to make a trustee of one of these trusts, you kind of have to think about those things. I mean, there are budgetary considerations, but there also are benefit considerations for the trustee. And they're tough decisions every day. And I mean, our staffs here, we make decisions that make people unhappy a lot just because sometimes it's in their best interest. But we also have the opportunity to do great things for people sometimes, and things that people wouldn't be able to do on Social Security. So it is a balance. This slide is like completely out of order. I realized that when I was sitting outside, so I don't even know where this should be. But I think we all know what a last will and testament is, but I just sort of want to make a couple points about wills before we talk about third-party trusts. So again, we all know what a will is, and we all probably also know that there are services out there like online things or free things that you can make your own will and kind of do it yourself online. That is really not recommended when you're talking about planning for someone with disabilities. There's very specific language that you have to include in your will, in your trust, in order to protect benefits. So if you're working with a lawyer or working on your own and you're not sort of aware of those requirements, you might go ahead and create a plan that doesn't really work. So I do recommend, as painful as it is to deal with lawyers, and I can say that as one, that you hire one. So, I mean, we have a lot of great lawyers that we recommend. So if you don't know where to start, feel free to call us and we'll point you in that direction.
You mentioned, or at least it was on one of your slides, about a letter of intent. How does a letter of intent, an estate plan, and a will fit together?
Okay, so I mean, the estate plan is kind of the overarching term. The will, the trust, the letter of intent, the future planning guide, that's all part of the estate plan. So you're looking at all of your assets in general and thinking, okay, how do I want to leave these assets to people in my life, whether it's my child with a disability or not, and you're making that plan in advance of your own passing. That's the reality. Now, within the plan, again, I always recommend having a will, regardless of who you're planning for. You want to have a will because you are able to say what happens to your money, your things when you pass away. The letter of intent is sort of a supplemental document that really you can work on your own. So we have a future planning guide. It's how many pages, Patty? Like 110? It's a very, very long document, and it's free on our website. And it really, again, it goes through and just talks about future planning guide. Yeah, it is on our website, and we can provide a hard copy as well. But it's a supplemental document. It's not really legalese. It's just you recording kind of what your hopes are for the money that you're leaving to people. So if, just an example, we see sometimes every year our family has gone on a vacation to Myrtle Beach. It's really important to us, if the trustee can afford it, to continue to allow our son to go to Myrtle Beach every year. Like, that's a priority of ours. Now, it's not a guarantee that we can do it. What if we don't have the money? There's factors, but it helps the trustee understand, okay, that's an important goal for this trust. It's something that we need to work to make happen. So again, this isn't legal, it's supplemental, and it's just you're recording your wishes and desires and the wants and likes and dislikes of the person with a disability. And that's just there's one piece of the plan. There can be many pieces of the estate plan. That's just one of them. So, and again, dying without a will when you're talking about planning for someone with a disability is, it's a worse scenario. I mean, obviously, if you pass without a will, you don't get to determine where your assets go. It will go according to state law. But when you have an individual with a disability that's part of your, close-knit family, they will receive money more than likely outright. And we talked about that. We don't want to leave money outright to the individual with a disability. It puts their benefits in jeopardy, and it forces them to use a type of trust that's going to be less flexible and that there's going to be less control over into the future. So we really do, again, as part of your plan, have a will. At least have some special needs trust language in your will so that any money that you are leaving to an individual with a disability goes right into that special needs trust that you've created, not directly to the individual. Okay, so that's really what I just described there is what a third-party trust is. It's when someone other than the individual with a disability creates a trust and funds the trust for the benefit of that individual. So the money that we're talking about here never belongs to the individual with a disability. It's the decedent's money that goes into an estate. The estate pays it directly to the trust. The trustee starts administering it for the beneficiary. It never touches the hands of the individual with a disability and therefore causes no interruption to benefits. So one option, and a very common option we see is to incorporate third-party special needs trust language into your will. You talk to the attorney about it and just say, any provisions that I want to leave for my son John, I need those funds to go into a trust for his benefit, and it needs to be a special needs trust, supplemental needs trust. Those terms are sometimes used interchangeably. And again, the key is that the attorney knows the planning, they know how to do this type of planning, and they're including the language that's necessary to protect benefits. So if you have a family attorney that you're not sure, do they do this type of planning? I'm happy to review them. I review trusts all day, every day. Some people are naming us trustees, some people are not. I'm happy to give them a quick review just to make sure that they have the requisite language and that they won't cause problems into the future. So that's sort of like the simplest of ways to do a plan. You do your will and you incorporate supplemental needs trust language as part of the will. Anything passing to the individual with a disability goes right into the trust and immediately protects benefits. The great thing about third-party trust is that you, as the person creating the trust, gets to control what happens to the money when the beneficiary passes away. So we're obviously putting the money into trust to benefit the individual with a disability while that individual's living. But at that person's passing, if there is money remaining in the trust, you as the person creating the trust gets to decide where it goes. So whether it's to other children or family members, grandchildren, nieces, nephews, charities of your choosing, you get to decide where it goes. And that's really important because it's protecting your legacy. You've accumulated wealth during your life. You want it to benefit your individual with a disability, but you then want to be able to say, I want it to go to my grandkids or I want it to go elsewhere. So you keep control even beyond really from the grave. You're controlling where the money goes generationally. So that's a very big advantage with this type of trust that you won't have with pooled trust or payback trust, which we'll talk about. Those are first-party trusts. So again, when we're talking about planning, you're here today, so you must be thinking about planning in some way. These are the things we want to think about now while we still have control over our own estate plan. There's no payback to the Medicaid agency in the state. And again, we'll talk about in a couple slides with payback trusts that, certain types of trusts, when the beneficiary dies, the money has to go back to the state. It has to go back to pay Medicaid for any services the person received during their lifetime. If someone's on waiver, if someone's in a nursing home, those liens with the state get high very fast. I mean, we're talking hundreds of thousands to millions. So the chances of there being, money left over after a payback to the state are slim. So we don't want to subject, again, our generational wealth, the money that we plan to leave to someone, to that type of payback. And additionally, there's no age limit to when a third-party trust can be established. So we'll see with first-party trust that once someone reaches age 65, the law starts placing big limits on what's available. That is not the case with third-party trust. You could be 70, you could be 80, you could be 90 when a third-party trust is set up for you. There's absolutely no age limit. So that's another key thing to remember with this type of trust. So to the trustee point, so a big part, I think I find when I'm talking to people about their estate plans and creating a special needs trust, it seems that choosing a trustee often is the toughest part, because you're kind of thinking in your mind, I have family members who I want to be involved, so I'm really thinking about making, my other children a trustee or a co-trustee. Then there's consideration, do I need a corporate trustee? Do I have enough money to access the bank that I use? Or do I want to use a nonprofit? Do I trust a third-party agency to do the trustee work? I think that decision as part of the plan is probably the toughest and one that people mull over the most. So just a couple things to consider when you're naming a trustee of a special needs trust. So the trustee's relationship to the beneficiary. We probably once a week take over a trust where the non-disabled child is like, I want nothing to do with this. I'm resigning. I need a corporate trustee in place. Because who wants to ask their sibling for money? I mean, sibling relationships can already be tough enough. And then you've got, an individual with a disability having to go to a family member, ask for things. I mean, that sometimes hurts their pride. It's just not always the best scenario. So consider that. I mean, if you're looking at that, is that something that's going to work for your children?
And something I would add to that is, as a person with special needs, you still need a sibling, and you need a trustee. Sometimes that shouldn't be the same person. Maybe that should be two separate people, because the trustee relationship can then fracture the sibling relationship, and then you don't have either. So I just want to point that out.
Very fair. And I think that's why a lot of siblings do, when their parents name them trustees, sometimes they don't even know that, and they find out and they're like, oh, forget it. Like, that's just going to be the end of our relationship, having to haggle over this type of stuff. So they do get out. Consider the time and organization that it was required to administer trust. So, I mean, in addition to obviously making the disbursements we talked about, you need to know government benefit rules. What can we pay for? What can't we pay for? What will impact SSI? What won't? Those types of things. Money really should be invested when we're talking about it. We want it to grow over time. If it's just sitting there, it's stagnating. It's not keeping up with inflation. We have to file annual fiduciary tax returns, which is, that has to happen every single year. So there is work involved in being trustee. And this is not even a good joke at this point, but I usually do bring up, just when I've just in my life and talking with clients, particularly about naming executors of estates as well as trustees, they start becoming like sentimental about it. Like, oh, like my oldest child, like I have to like reward them with that job. It's not a reward. It's horrible. So like, I mean, really, you have to want to do this work and be available to do it. So like naming your brother-in-law in Indonesia as the trustee is like a horrible choice, because he's not even in the time zone. He doesn't care. So again, be aware of that. It's not like a gift. It's not an honor. It's a job. So when we're choosing a trustee, we really need to think about that. And again, you have to know about the disbursements. That's probably the most important thing, because even when you talk about hiring a professional trustee, like in a bank or something to that effect, they oftentimes don't have a lot of, grounding in benefits. They do hold themselves out as serving as trustee of special needs trusts, but when it comes down to getting into the weeds on some of these benefit issues, they're not always great. I can't tell you how often some of the big banks locally that we take trusteeship over, they were just giving cash out to the beneficiary. They weren't keeping records. I mean, just an absolute mess. And all of that can put benefits in jeopardy. So you want to think about, does the trustee know what's going on with benefits? It's a pretty important thing. Yeah, there's absolutely liability to the trustee for that kind of behavior. But oftentimes when individuals are administering these things, they don't think about the liability or understand it, and it's too late to undo some of that. So again, big decision as part of the plan. I don't mean to make it sound frightening, but it is a bit. So one of the things to consider is if you do have an individual in your life that you want to name trustee, you have the option of naming that person as a co-trustee with a corporate trustee. So Achieva Family Trust serves as trustee of all the types of trusts and oftentimes with a sibling or another family member. So what that's really creating is it's putting the onus on the corporate trustee to do all the work I just said, but it's allowing the family member to stay involved. So they can participate in disbursement decisions to the extent that they want to. We have some co-trustees that say, like, you know, if it's like a day-to-day like cell phone bill or cable bill, you don't need to call me about it. But if he calls and says he wants a car, like, I need to know what's going on and I want to help participate in that decision. And it also allows the individual to remove the corporate trustee. So if you do have concerns about leaving this to a corporate trustee, you can give your individual family member that ability to remove if it's not working out. So they kind of have that oversight and keep an eye on it when you're not able to. So just some things to consider there. Another big thing to, oh, yep.
How complicated is it to have multiple siblings as co-trustees?
Well, it's very complicated. I really don't advise, I mean, co-trustees, again, a corporation and a person is one thing. Multiple people being co-trustee together can create mayhem. Because
Right. And if you're going to designate 2 trustees, somebody better be a tiebreaker.
Right. That's
And
it.
then you don't want to get to the point where you name 3 trustees, because then that's just getting unruly.
Correct. And yeah, I mean, that's the reality, because if you have a situation with 2 co-trustees that can't agree, now you're in court having to make every disbursement decision, and that's just going to cost money and take time and really just defeat the purpose of everything. So I don't want to say that it can't work, but I mean, you know your people, you know your family members, like, are they able to get it done? I don't know.
Well, my point is, you know your family members. Do you know your kids' spouses who often exert influence? Do you know your spouses, or do you know your child's kids, your grandkids? Are they going to assert influence? Because remember, if ultimately they are the recipients of that money in the long run, that just, even if it's not, it creates an idea that there could be an interest in what you're giving out.
Correct. I mean, you know, we all know family dynamics are tricky. So, you know, I find that if you can't move away, if you really do want an individual involved, you know, a co-trustee relationship is sometimes the way to go, because you have that involvement, but you don't have all of this stress that you're placing on the individual. So not a bad way to go. Beneficiary designations, another thing I want to point out. So really important, particularly, you know, nowadays where a lot of people's assets are tied up in beneficiary designated accounts like life insurance, IRAs, annuities, things of that nature. We want to make sure that we change those beneficiary designations to reflect the plan. So I can't tell you how often I'll have someone do a will, do a supplemental needs trust as part of the will, and then all of their assets are either transfer on death accounts or beneficiary designated accounts that aren't going through the will. So you have to change your beneficiary designations to the trust that has been created. Usually that just requires naming the trust by name, sometimes the date that it's signed. There are outliers where the annuity company or the life insurance company will want a tax identification number for the trust. That is possible. You can obtain that. I usually try not to until we're actually going to fund the trust, but it is a possibility. So, you know, you have to really look at, as part of your plan, you know, what do you have? Do you remember the life insurance policy from 1978 at your first job? And is your ex-husband still the beneficiary? Like, we have to look at those things and figure it out. And if we are trying to designate the individual with a disability, we want to designate their trust. Because if we designate them specifically, it becomes first-party money belonging to them, and it can no longer go in the third-party trust. Again, we'll have some first-party trust options, not as good as the third-party trust option. So we want to make sure that anything that we're leaving to the individual with a disability is left directly to their third-party trust, and that means reviewing all beneficiary designations. Your lawyer should be doing that with you anyways, and you should look at beneficiary designations at least every 5 years, and certainly after big life events, deaths, births, things of that nature. You know, the plan is constantly changing and needing to be looked at. You don't just get to go to the lawyer tomorrow and then in 50 years it all checks out. You've got to constantly keep up with your plan as we're adding family members, subtracting family members, and as life events occur. So it is an ongoing process. But these are just some things that were, to get you started in that process. Okay, so I'm going to pause there because we're going to switch gears and talk about first-party trusts and ABLE accounts. Probably not ABLE accounts, but is there any other questions about third-party trusts or what we're saying here?
I mean, generally with Achieva Family Trust, I'm assuming you got to get paid. Is there like a percent? What's your percent per year or something?
Yeah, so we have a fee schedule that's based upon the amount of money under management. So there are different breakpoints. The fee generally gets less the higher the value of the trust. And that's pretty standard, I would say, probably for most corporate trustees. It's not like a flat fee. It is a graduated schedule based on what's under management. So I'm not sure if we have fee schedules in the building, but we have them on our website and we can certainly provide them. So good question, though.
And then I want to make sure I understand what Achieva Family Trust is.
Sure.
I was just over here in this room and it talked about an organization called ARC, which I think is a government organization.
It's a nonprofit also.
It's a nonprofit? Okay, so ARC's a
Yeah.
nonprofit. Achieva is a subgroup of ARC, just Achieva.
Or reverse. ARC is a subsection of Achieva.
Yeah, so
ARC's big, I thought ARC
well,
was
ARC
over
is a
the-
national organization.
ARC, yeah,
ARC
that's
is a
what I thought.
national organization. We used to be the ARC of Greater Pittsburgh, but now the ARC of Greater Pittsburgh is kind of under Achieva. So
Okay.
it's a little bit confusing, but similar. Yeah.
Okay,
Go
so-
ahead. We're on the right
okay,
track.
Okay. And so both those are nonprofits.
Correct.
Achieva Family Trust, is it within Achieva or is it really separate?
It's a subsidiary of Achieva.
Okay, it's a so I've never heard of I'll call it an investment company, so I don't know what you call it, a financial planning company inside of a nonprofit before.
Yeah, so, and I think that's the key. I mean, we're not a bank. We're just simply a nonprofit corporate trustee. All of our investments are done through PNC Bank and the Capital Group. So we're not investing money. We're just kind of calling the shots about it, right? And I guess I'm here doing financial planning, but we do a lot of planning discussions, right? So, I mean, I would be the last person you'd want me to actually tell you what to do with your money in terms of like how to invest it and be in this and not be in that. But, what we do, our education and outreach team and myself, we're just talking a lot to families about estate planning more. And I mean, estate planning and financial planning are obviously very much connected, but we're not out here for profit doing this type of planning. We're doing it as just part of our nonprofit mission.
Financial planners.
Correct.
I think this gentleman had a question.
Yeah. So if you have an external fund to Achieva that you're accumulating funds in, can transfer that into the third-party funds throughout the year?
So like, you mean if you have like a bank account or something of that nature?
Investments.
Yeah. So I mean, yes, you can. You as the third party can always add any form of money, investments or stocks or cash or whatever into a third party trust. Yes, that is a possibility. Now, can it
The
remain?
estate, if it's part of the estate, then?
Yes. So, I mean, when you pass away, your executor of your estate, their job is to basically gather all of your assets. So liquidating accounts and selling off houses and cars and property, and all that gets thrown into a pot. And from that pot, you're either deciding that you want a certain sum of money to go into the trust or a certain percentage of your estate. So some people say 100% of my estate into a trust for my child with a disability. Some people might say $100,000. You can choose how you want to divvy up your estate to the trust.
Okay, but that has to be designated as not part, in other words, the person that it would be the beneficiary that is autistic.
So
That could not be in their name whatsoever from the trust.
not
It has
to
go
benefit
to a
from.
separate fund altogether.
So you would want to, like, if you have an account that is, what I'm sort of speaking to here is if you have a beneficiary designated account, like think of like a life insurance policy. You buy a life insurance policy, you have to choose a beneficiary. You would want to list the trust as the beneficiary, not the individual with autism. Now, right, and if it's not a beneficiary designated account, like it's just a bank account or it's just like a mutual fund or some kind of portfolio, it will go to your estate. It will be liquidated and brought in as part of your estate and be dispersed according to your will. we're having a side chat. Okay, go ahead. Yep.
Say you already have like life insurance and you have CDs and a credit union and you have all these things with the person with disabilities as the person receiving it if you pass. You're saying once you create the third party, you have to go back and contact all of those things and remove the person's name and list it as a third party. And what if you forget one of those? Then it'll go to the person
Correct.
and then might screw up their SSI or
And then you're
whatever.
going to open a pooled trust, which we're going to talk about next.
Oh, okay.
Yeah.
Perfect. Sorry.
Which
See?
isn't,
No, it's a good segue. Not as good, but a good segue. Yeah. So, okay. So we just covered third-party trust, and the key elements to a third-party trust is that someone other than the person with the disability is setting it up as well as funding it. So we never can place money that belongs to the individual with the disability into a third-party trust. So if just over time all of your relatives have been throwing money into a bank account and it's in the name of the person with a disability, it can be liquidated and placed into a trust, not into a third-party trust. Same thing. If they inherit, you had mentioned you have a life insurance policy that you forgot about, and it lists your child with a disability as the beneficiary. When the time comes to make the claim for that life insurance policy, the individual with a disability will have to accept that money outright. It will become their money, and then turn around and place it into a first-party trust. They cannot put it into the third-party trust that you created for them. It will have to be a separate vehicle because it became their money. It lost the characterization of third-party money as soon as it was paid to them directly. Does that make sense? That's like a very important point, like that we have to understand, because the source of the funds tells you what type of trust the money's going into. So, and I'll give some examples of that when we talk about pooled trust. So, so with pooled trust, Achieva Family Trust has our start in pooled trust. Legislation occurred in the 90s that allowed first both of these types of special needs trust, pooled and payback. And the key element for a pooled trust is that you had to have a nonprofit trustee. So you can't have an individual, you can't have a bank, it has to be a nonprofit. So Achieva, as our parent organization that had existed since the 1950s, saw that that was a space that we could provide another service by serving as the nonprofit trustee for pooled trust. So that's kind of how we got our start, just serving as trustee of pooled trust. We've since expanded and we now serve as trustee of third-party trusts as well as payback trusts. But that's sort of how we started with a nonprofit. So with a pooled trust, there's several differences which I'll highlight from third-party trusts. So in terms of who can set up the pooled trust, it has to be this very specific class of people, either the individual with a disability themselves, a parent, a grandparent, a legal guardian, or a court. So a sibling can't set up a pooled trust for someone. A friend can't set up a pooled trust for someone. It has to be one of those classes of individuals. So again, that's something to keep in mind, because do we have that class of people available? Is the individual capacitated to the point that they can actually set up their own trust? If not, do we have parents or grandparents that are still living? Have we done a guardianship or had powers of attorney? Or do we have to go to court to have this set up? The beneficiary has to have a qualifying disability under the Social Security Act. We're not going to get into the weeds with that, and we tend to be a little bit more flexible with pooled trust and payback trust, but Social Security is looking at an individual's ability to earn, have work, and basically have substantial gainful employment. So they're looking at someone's disability and saying, is this chronic? Is it lasting over a period of 12 months? Are they able to work? And if so, can they work gainfully? If not, they'll likely get that disability designation that we talked about in the benefits piece. So the individual of a pooled trust should be under the age of 65. The federal law that allows us to establish pooled trust does not prohibit us from setting up a pooled trust for someone when they turn age 65 or older. But the treatment of the transfer of funds into a pooled trust for someone over 65 is problematic. So we talked about before, we can't give away money for less than fair market value as a means of becoming eligible for benefits. So Pennsylvania Department of Human Services, as well as Social Security, views transfers into a pooled trust for someone over the age of 65 as a transfer for less than fair market value. So essentially a gift. So if you're receiving services through Medicaid, receiving SSI, and you're 65 or older, and you transfer your money into a pooled trust, it can and likely will be penalized by those agencies, and it will render the individual ineligible for services. So it's not that we can't set one up, it's just that depending on the benefit they're receiving, it could lead to immediate termination and or a period of ineligibility. So we really, again, don't want to count on a pooled trust for someone over the age of 65. There's too much risk associated with it. So again, if you're leaving money outright to someone and they're 66 when they receive it, they're going to have a problem. We wanted to create a third-party trust there. We don't have to worry about their age in that case. Again, a pooled trust has to be established and maintained by a nonprofit. And the nice thing about pooled trusts is that you don't have to have a trust document drafted with an attorney. We have standard form joinder agreements that, again, it's the individual or the other class of people that can establish the pooled trust, completes and signs those joinder agreements, and they join the individual to the pooled trust. So the pooled trust is governed by an overarching trust document that's already been reviewed and approved by Medicaid, by Social Security. So you don't have to go to a lawyer to have a pooled trust drafted. That's already been done for you. You just have to have the joinder agreement completed and signed to join the individual to the larger pool. We call it a pooled trust because funds are pooled for investment purposes, but accounted for separately. So if we take everybody's in the room $10,000 and throw it into a pot, we're going to have a lot more options in terms of investments, the different types of funds that we can get in. It's going to allow us to serve as trustee for a lot cheaper than if we were individually managing everyone's $10,000. So we are accounting for it separately. You're obviously seeing money going in and going out of your own individual account. But for investment and administration purposes, the money of everyone in the pool is thrown together in one pot and invested accordingly. So again, we do get better returns on investment. You know, 100 million is going to do better than 10,000. You're just going to have access to a lot more funds and again, just better gains. So here are some of the critical pieces to understand. So at a beneficiary's death with a pooled trust, in particular with Achieva Family Trust pooled trust, money remaining in trust at the beneficiary's death stays with Achieva Family Trust to be spent through our charitable residual program. I don't know, I think someone probably is here from residual out in the vendor area, and Leanne is in charge of residual, but we give grants to people with disabilities in Pennsylvania. So it's a really great program. We love the program. We've done millions of dollars in disbursements for people who have, variety of needs. We do assistive technology. We've done vehicle adaptations, send kids to camp, all kinds of things. So it is a great program, but in terms of, again, when you're talking about your own estate plan, and you might find that to be what you want your money to do when the beneficiary passes away. But there's no option with the pooled trust for money to go to other family members. So if the beneficiary passes, it's going into the residual program. It's not going to be able to go to your other kids or to your grandkids or what have you. So again, it's not the greatest estate planning tool. We don't want to rely on the pooled trust to leave inheritances to. But it is a nice tool.
Unless you were going to leave it to charity anyway.
Unless you're going to leave to charity anyways, then you may not care. But you might have other charities that you want to leave to as well. And so, there's one thing that will happen with funds remaining in a pooled trust with us. And again, it's going to go to this charitable residual program. So what it is nice for, though, again, and an example that we had before, so say that someone forgets about a life insurance policy that they had, many years ago, and it's a $25,000 life insurance policy. We can open up a pooled trust very quickly for no cost to shelter that $25,000 into the trust so that it doesn't impact benefits. So you have that option. Some things that people typically use pooled trust for, again, small life insurance policies, small inheritances, small personal injury settlements, Social Security back pay, if someone had, say, like an UTMA account that had been accumulating and then they need to go on Medicaid, you can liquidate that and place it in the pooled trust. So it's really nice for small sums of money because you don't have to spend money to get it done.
And Jackie, here's a question. Can you have both a pooled and a third party?
I like this little tag team thing that we're doing. Like, you're like peppering me with questions. I'm here for it. Yes, you can have both a third party and pool trust. We have a lot of people that do. Again, we're hoping that everyone's doing a third party trust as part of their plan. So everyone's going to have one of those. But if there are circumstances that come up, someone has extra wage income that accumulates, or their rep payee account gets too large and they need to transfer funds. Again, they come into a small settlement or inheritance. They can place that money in the pooled trust. The pooled trust then works in conjunction with the third party trust. We will spend the funds in the pooled trust first to protect the remainder beneficiary's interest in the third party trust. That's how we handle it when we do have two, but it's not uncommon that we do. So there are circumstances that come up that are just unavoidable, where someone will have both trusts, and that's totally fine. We just don't want our inheritance to go into a pool trust. Correct. Correct, but that's beyond the scope of this course. Yeah, every pool trust company has a little bit of a different way that they handle it. We happen to do 100% retention to charity. Some pool trusts pay back Medicaid, just like a payback trust, and then money could be available to family. So it really just depends on the pool trust company. Do your research there. There are several in the Pittsburgh area and across the state, but that is how we handle it. There are some options there, and that's, again, completely governed by the pooled trust itself. So really quickly, I don't want to waste too much time on these because Patty told me that people don't like to hear about payback trusts. So I don't want to waste too much time talking about them, but they're very similar to pooled trusts. There are some primary differences that I just want to highlight. So again, when we're talking about a payback trust, we're talking about money that belongs to the individual with a disability for the most part. That's going to be the source of funding. And we're usually talking about larger sums of money. So when we are opening up payback trust, it's generally funded by like med-mal claims, personal injury settlements, hundreds of thousands, sometimes into the millions, larger sums of money. We typically do recommend a payback trust. The reason for that being is that, as I mentioned before, with a payback trust, at the beneficiary's death, we do have to pay back the state Medicaid agency for any Medicaid the person used during their life. But if we have a massive settlement, we are likely going to have enough money to pay that claim, and then money remaining can then be dispersed out to family members. So again, when we're talking about small sums, the pooled trust is usually just easier to kind of manage. We might not be worried about remainder funds because the amount is so small. We plan on using it during the beneficiary's life. And also, again, with the pooled trust, we don't have to pay a lawyer to draft anything or anything of that nature. With a payback trust, we do. So if you're going to have a payback trust, you're looking at probably a few grand on the front end to get it drafted. It has to be approved by the Department of Human Services. So if we're talking smaller settlements, back pay, what have you, the pooled trust is usually the way people go because they're just easier, faster, cheaper. But when you start talking about larger sums of money that the individual beneficiary has for whatever reason, and like I said, it's usually personal injury settlements, it is worthwhile knowing that the payback trust exists because, again, there is that possibility that remaining funds could end up with family members if the DHS lien is paid back in full.
And I would just add, as someone that works with the residual program, the charitable program, that when you have that small amount and you're going to go either payback or pooled, payback, all the money's going to go to Medicaid. Pooled, it's going to go to other people with special needs. Just point that. That's my charitable plug for the day.
We'll take it. I like it. So yeah. So this is not. I don't even like to emphasize first party trust too much in this session because we shouldn't even be thinking about needing to use those because we're all going to leave here today and we're going to call our lawyers and we're going to get third party trust drafted and we're never going to worry about first party trusts, right? Right. Okay, or we're going to call me if we're still confused and we'll talk about it. And then we'll go from there because I'm starting to talk fast and get stressed because I know we're running out of time. Okay. All right, so to belabor these points, so again, myth, you have to be rich to have a special needs trust. No, again, nonprofits generally have really small minimums. Ours is $500. So it's not inaccessible to you if you don't deem yourself to be wealthy. And it's very much likely that you will still need it because of the low resource limits that SSI and Medicaid have. And again, implementation of a proper estate plan that includes the individual with a disability really should be done by an attorney. Again, I get it. They're expensive, they're annoying, but they are important for this type of planning, because not putting the right language in will defeat the entire purpose of the plan. And again, a lot of do-it-yourself websites and things like that, they don't incorporate state law, they don't incorporate, Medicaid rules, Social Security rules. So you really don't want to do this one yourself. Talk to a lawyer. And like I said, again, if you don't know a lawyer or don't know where to start, please contact us. We do have a really nice recommended attorney list all across the state of Pennsylvania, not just here in Pittsburgh. And also some great nonprofits that we work with that do legal work at a discounted rate. We work with the Pitt Legal Clinic. They've done several special needs trusts for us, for clients for no cost or a very low cost. So, if cost is an issue, no problem, let me know. We have some resources available for that. And then a lot of great attorneys that do pro bono work for us too. We're hoping to one day, again, have a legal clinic where we actually bring lawyers that we work with into our offices in Pittsburgh and have them actually do free consults with people. So stay tuned for that, because Patty will be putting that together probably within the next year. So that'll be good. So that's helpful. All right. So ABLE, we do have a few minutes to talk about that. So ABLE stands for Achieving a Better Life Experience. I do believe we have an ABLE table here today. Am I right about that? Someone's in the vendor thing, so feel free to chat with them about it. So ABLE has nothing to do with it. We don't. Maria's telling me we don't. Okay, I stand corrected. You can talk to me about it. But Achieva Family Trust doesn't administer ABLE accounts. This is a state-run program. In 2014, there was legislation signed that created a new section under the 529 section of the IRS code. So if you're familiar with 529 educational plans, these are 529A plans. And again, it falls under that subsection. 529 plans are created for educational expenses. 529A or ABLE accounts are created for qualified disability expenses. So that would include education, but it also includes a lot of other things that an individual with a disability may need. Pennsylvania has its own state-run ABLE program. There is the information there, the website and the phone number. We're happy to talk with you about ABLE at Achieva, but we don't actually set the accounts up. You do have to do that through the State Department of Treasury. So a couple things to be aware about with the ABLE account. So the beneficiary is the account owner of the ABLE account. It functions a lot more like a bank account than a trust. So there's not a third party standing between the beneficiary and their money. They're able to access it with a debit card. They're able to spend in the community like a credit card or debit card. They can get cash from the ABLE account. So for a lot of folks, that's really nice. That's financial freedom that they otherwise may not have. For others, it's not so great. It really just depends on the individual. Again, if there's a concern that someone could be taken advantage of or that someone is not able to manage money, sometimes ABLE accounts can be tricky that way. You can have authorized signers on the account, but that doesn't take away the fact that the account belongs to the individual with a disability. So to the extent that they have the ability to access it, they can. And authorized signers that doesn't change that reality. The beneficiary has to have a disability onset before the age of 26. So that is changing in 2026, I believe. They've changed the federal rules on that. You will be able to open an account if your disability was onset before age 46. So they've increased that age limit, which is really nice. The 26 age limit is fairly limiting for a lot of our beneficiaries. Mental health diagnoses sometimes don't, and autism sometimes aren't diagnosed until past the age of 26. So if we don't have the medical records to back that up, the ABLE account isn't accessible. And same thing with physical disabilities. If you get into a car accident or something like that later in life, ABLE accounts just have not been available to everyone. So they are raising the age limit, hoping to expand the program. And I think it is 2026. Contributions into an ABLE account are limited to $17,000 a year. So that's a big difference from a special needs trust. You can place any sum of money in a year or over the life of the beneficiary into a special needs trust. That is not so with ABLE. So you are limited to $17,000 a year from all sources. So if grandma comes through January 1st and puts $17,000 in the ABLE account, everyone else is limited from contributing to that account until the next year. So again, not a great option for, say, an inheritance pittance or some larger sum of money because you won't be able to put the entire amount into the ABLE account. But really nice for smaller sums. If someone's working and they're getting, some income, or if you have family members who want to contribute birthday gifts, things of that nature, the ABLE account can be really nice as an option there. You don't need to necessarily open up a trust for those types of things. Something to be aware of with ABLE is that SSI recipients can only save up to $100,000 before their SSI could be impacted. Once their account reaches $100,000, their SSI will be suspended. They'll keep the Medicaid attached to the SSI, which is good, but they will stop receiving the cash benefit. So obviously at $17,000 a year, that's going to take several years to get there, but keep that in mind for someone that is on SSI. Remainder funds in an ABLE account, when the beneficiary passes away, it can do one of two things. It can be transferred to a disabled sibling without issue, and if not, the funds in the ABLE account will go into the estate of the beneficiary. At this point, Pennsylvania does not have a payback provision to their ABLE account. A lot of states do. The federal legislation allows the states to decide that, so Pennsylvania elected to not have a payback provision, meaning the money doesn't go directly to Medicaid out of the ABLE account. I would anticipate that will probably change at some point, but who knows? Right now, that is not the case. So that is something that's a positive in terms of being part of Pennsylvania's ABLE account program. So I mentioned disbursements from the ABLE account have to be for quote unquote qualified disability expenses. I'm not sure anyone knows exactly what that means because these aren't being really regulated, but I've included a lot of the same things that you can spend out of a special needs trust. So education, housing, transportation, employment training, assistive technology, health, wellness, legal, those types of things. But I want to highlight the basic housing and living expenses. So the Social Security Administration will not penalize the individual ABLE account owner for paying for rent, utilities, or food from their ABLE account in the same way they will penalize the disbursements from a special needs trust. So if you have an individual on SSI, they can pay for shelter costs from their ABLE account without worrying about that 1/3 reduction that I talked about earlier. So we have a lot of people that will use ABLE accounts in conjunction with special needs trusts for that reason. We can move money from a pooled trust or a third-party trust into an ABLE account and allow the beneficiary to use their ABLE account to pay for shelter costs so that they won't get that reduction. If we were paying it directly from the special needs trust, they could get dinged by the Social Security Administration. At this point, Social Security is not penalizing these ABLE accounts. So that's a really big, it's a pretty massive development in terms of this field because that's always been a limiting factor around special needs trusts. Yeah, the question is, can you have an ABLE account in a special needs trust? Yes. And you can transfer funds again from a third-party trust or a pooled trust without problem. Payback trust, the State Department of Human Services is saying no to that because of the fact that we don't have payback provisions in our ABLE. So pooled trust, third-party trust, you can move money from those trusts into an ABLE account and you can have them both together. Up to $17,000.
And Jackie, the ABLE rules for Pennsylvania, they would differ from other states, correct?
Yeah, so
So if you moved, it might change?
Correct. Every state has the ability to administer their ABLE program a little bit differently. So, if you move and maintain your Pennsylvania ABLE account, which you can do, the rules of Pennsylvania will dictate. But if you leave and move to Ohio and open up what they call their account stable accounts, and you open up a stable account, you're now going to be governed by the rules in Ohio. So you can only have one ABLE account. So you're not going to have an ABLE account in Ohio and in Pennsylvania. So, the state rules of where the ABLE account is set up is going to govern. But to your point, it's going to be if the Ohio Medicaid agency finds something that's running afoul with the Pennsylvania rules, that could be problematic for the person's benefit. So I would definitely research that before. That's always an issue with moving, right, with benefits. People move all of the time from Pennsylvania and go to Florida and think they're going to get the same services and they aren't. So I always recommend, that's a big part of, trusts are not that way. For the most part, trusts are going to be transferable state to state. ABLE, it could be a little bit different. I'd check with the ABLE before I would, that would be a consideration I'd have before I'd move. But the SSI being a federal program, that's going to apply. The 100,000 will apply no matter what. The contribution limit's going to apply no matter what. It's that payback piece that's really usually the biggest difference across the states. Some have it, some don't. Okay, finally, and we are out of time, but we will get to this last slide. So a couple things, I think I already mentioned some of this. So just some things to be aware of. A lot of people ask me, well, I have a 529 education plan. Can I transfer the money from the 529 education plan to the ABLE account? Yes, but only at the $17,000 per year. So you can't take a $500,000 529 plan and just make it a $500,000 ABLE account. You've got to move it the $17,000 at a time, and it will not be penalized. Able to Work allows individuals to save more than the $17,000 per year up to the federal poverty limit, which is a little over $14,500 for 2023, provided that the individual's not participating in a work-sponsored pension program. So if you're not involved in some kind of savings program with your employer, you do have the ability, if you're working, to put more than the $17,000 into an ABLE account a year. So that's important. And again, I mentioned, beginning in 26, the age minimum will increase to 46, and so this will make it a bit more available to people who had later in life disability onsets. Questions?
That ABLE account, is there a charge on a yearly basis for that?
Yeah, they have a charge. I do think it is an annual charge.
Okay.
I don't know what it is. Do you know what it is? Is it quarterly? It's pretty inexpensive. And in terms of how the money sits, there are different options. You can put it in just a basic checking account, and I think they have 5 different investment options as well, from conservative to more aggressive. So it can actually be an investment tool in a way. It just depends on how you want to set it up. Yeah.
Yeah, I was just curious about direct depositing SSI money into an ABLE account. Is that a good idea? Can you do that?
No, and it doesn't. So a lot of people ask me that too. They're like, well, if I have my employer deposit my income directly into the ABLE account, does it mean it's not income? It's all still income. You really need to use your SSI for shelter costs. That's what it's meant for. And that's the biggest thing that SSI is looking for. They want to see that you're actually using it for shelter costs. So if you're using it just to put away in the bank, that's a problem. They don't want to see that accumulating. You could lose it that way. So
Okay, so it'd be better to have to
spend
a
it,
separate
spend it on
account.
shelter.
I guess that's like representative
Yep, a rep
payee
payee.
account.
Yep.
That's recommended. Okay,
Yep.
thank you.
They'll require, Social Security will require that too.
And if you have that account and it gets to be too high, if you have a separate account and it gets too high, you can transfer into ABLE at any time. So you're $500 over, take that $500 and
put it in an ABLE or a
move
pooled
it.
account, yeah. But with SSI, they really want to see you spending that. With SSD, it accumulates differently because sometimes it can be pretty high, but they really want to see that SSI is being spent on something that it's supposed to be spent for, not just saving. So,
although they are trying to change how we look at it with SNAP and food.
They are.
Because currently there's legislation that's been introduced, but
that they won't count food as a shelter cost. That's been in the works. So they used to count clothing as a shelter cost. They got rid of that. Now they're trying to get rid of food. So
there's also legislation pending right now about raising the $2,000 to $10,000, which, the $2,000 was set, I think, during the Nixon administration and has never been readdressed. So there's legislation out there right now, but can't even agree on a budget. So who knows what will happen to that?
yeah. Thank you guys.